it just won't connect, or it will just disconnect in mid-task, or you never know.
That can make it challenging.
The printer in my office has got so many profane names.
The printer in your office, what?
The printer in my name now has acquired so many profane names that I'm embarrassed to tell anybody what I call it.
What you do when your neighbors are getting on your Wi-Fi, you name your Wi-Fi deal. Instead of Jeff's house, you name it FBI surveillance fan number 7.
I've gone to a new system for my Wi-Fi. I'm using a ubiquitous system, and it lays a...
Went to A&M. Can you explain?
All my money went to A&M, so I'm very, very sympathetic to your cause.
Does this ring make me look like an
Yeah, when I was in college, they didn't have but about 8 girls there, and I decided that wasn't for me.
No, our freshman year was the first year they ever had more girls than boys.
Wow.
Yeah.
So
He got better every year.
I have 2 daughters. They both went to A&M. All my friends go to A&M, and most of the people I work with in my market went to TU.
Well, yeah, I took Dr. Dozier's classes in real estate when I was.
He just did, if you're interested, he just did a market update. He does one for us every year.
Dr. Dozier?
Yes,
He's still
and
alive?
if you will send me your, oh yeah, I like Mark.
You talking about the guy
Lori?
without the fingers?
Oh, no, Mark?
No. Must be his son or something, because he was old.
No, well, the guy before him was a guy named Ted Jones, and Ted's working for HOA, the Houston Association of Realtors. Ted is, most people don't know this, Ted is a Spitfire driver. He owns a British Marine Spitfire. And of course, there's only one seat, but I've seen him fly it. He's not bad.
All right, we got 30 people online watching. Whenever you want to get started, go for it.
Okay, you want me to
What's that?
say anything about why I'm here, or what my hopes are, or
What your hopes are?
what my aspirations are? Hope is not a good strategy.
Well, good morning. Thank you guys for joining us in person and online. This is one of my good friends and buddies, Bill Jones. He is very well respected when it comes to real estate in the state of Texas. He's a former commissioner of the Texas Real Estate Commission, and you serve as an expert witness a lot of times. In
A lot of
court
times.
cases
This past
for-
week we just
for
did that.
HOAs.
By the way, we won that.
It looks like you're in good shape. You won
Yes,
something.
yes.
Mr. Jones is going to take care of walking us through the HOA addendum, which is one of those things that I find so many agents actually just fill out based upon prior circumstances and what they've been told. And Bill, you're going to walk us through what it really means, right?
And a lot of other things.
And a lot of other things too. So take it away. Thanks so
Thank
much
you.
for being here.
Hi, everybody. My goal is to, in whatever way I can contribute, is to help you not make the mistakes I've made. Scott told you, I have endured a lot of litigation. I'm currently in 11 lawsuits with the HOAs that we manage. Last Thursday, we had a lawsuit that had been dragging on for about 4 months that they appealed, and we won it. This morning we got the decision on that, and hopefully we can go back and get some money from my HOA. So part of this about an HOA is to what I'm trying to share with you is to how they work and what your opportunities are to bring value to the relationship, to the conversation between the people you're working with, and sometimes, very often, the people you're working against. Real estate agents are notoriously guilty of saying somebody's got to help these people, they have no money, and so today's my day to play Perry Mason or whatever that part was that Andy Griffith did when he was an attorney on TV, and they want to practice law that the Real Estate Commission very strongly prohibits you from doing. And so you're going to hear me a number of times say to you that if you encounter facts that look like this, if you encounter challenges that look like this, if you encounter stupidity from the other side, title companies being absolutely among the most guilty of all of them, this lady, this is my bodyguard. If she does all this, and so if you encounter some of the things that she sees, first, a little dose of patience goes a long way. An opportunity to give whoever you're working with or against, I'm not preferential there, to talk to a lawyer. And when I say talk to lawyers, that's what you're going to see here today is what I choose to call a scraping off the very top of a 3-hour CLE class. The lawyers do credit for legal education classes. This is the most common things that I think you will encounter that should raise either a red flag or an opportunity for you to bring value to the relationship. You have been prohibited. I was at the commission when we took that word away from you. You cannot tell somebody the value of the property is. You're prohibited from using those words. Those are the Appraisal Institute's forbidden fruit. And you can use it in other anecdotal ways, but never to the point of saying this property is valued at. But what I'm talking about is a whole different value when you talk about something you have either purchased or something that you own, or you personally coming into the relationship saying that I'm going to bring you knowledge that you wouldn't otherwise have access to, or bring you experience that is simply not out there available. So this is my favorite billboard. Every day, virtually every day, we have people that call our office, well, I guess it had happened today because we called in, we hadn't had any of these phone calls, but we have people that tell us literally in a dozen different ways, in a dozen different languages, or perhaps more, you can't tell me what to do. Well, I'm going to show you how we can tell you what to do. So the interesting thing about HOAs is that they're really not a new invention. This background that you see here, I'll get out of the way. This background you see is one of my favorite things to point out. This is the Boston Commons. The Boston Commons was among the very, very first common interest developments, CID. That was a word that predated HOAs and POAs, but the Boston Commons was owned by the people that lived in the neighborhood. They commonly own this area. They have subsequently given it to the city of Boston to maintain, but it's one of the first evidences in America, if you will, of a common interest development, or what we now call HOAs. They've existed in one form or another for many, many years, but it wasn't until the 1960s when the Civil Rights Act really started to come into focus, and all the sensitive things that we're experiencing today really got their deep, deep roots. Part of it with Lyndon Baines Johnson signing the Fair Housing Act, the Civil Rights Act of 1964, 1968, we saw that revisited, and Nixon, is that somebody talking?
That was you talking, sorry.
So we saw the HOAs in what is clearly a prejudicial, racist approach to exclude people. We have neighborhoods in our community that certainly they've been voided and they're no longer enforceable, that prohibit identified groups of people. Me being left-handed, blue-eyed, I can use that example without crossing too many lines, but you can see how that prohibited people from moving into or buying or occupying properties in certain neighborhoods. Now, certainly in 64, again in 68, you saw where a lot of these things were changed, but nonetheless, HOAs originally had their roots in a racist, prejudicial approach to exclude people from certain neighborhoods. Now, all that's gone away from most, if not all, HOAs, but certainly is existing. You watch TV, you can see it literally with every newscast. The 1977 Clean Water Act brought a whole new level of opportunities. I think all of you will agree that opportunities are often defined by challenges. It's how you can sit back and say, this is a terrible challenge and I can't make this work and this is all against me and the world's against me. But then there are people that look at that and find that failures often lead to one less thing they have to do again to find the opportunity that comes from it. The 1977 Clean Water Act gave a lot of opportunities to words that I don't know if you see them up here in North Texas. We see them in Central Texas. We see them in South Texas a lot, called MUDs or PUDs, municipal utility districts. And this is where developers saw opportunities for ancillary income, where they could build a neighborhood, build these elements into a neighborhood. Probably the one where you used to be was the Blockhouse. Blockhouse is a famous MUD because literally they control everything. They redistribute water. If you read the Chapter 49 of the Texas Water Code, we even do this at our office, is we're allowed to buy water wholesale from an entity, either a city or some private water company, and redistribute it and charge and make money. So everybody's trying to find ways to defray their expenses and costs. Keep that thought. I'm going to come back to it again in just a few minutes. So one of the questions that always comes up is, who do I complain to? Who can I go to? Who can I, let me do this. Who can I complain to, and who can I say that you folks are not doing this right and I want to have your hide, or I want to have a piece of your backside, or I want to have you lined up against a wall and shot, or somebody has hurt me? Well, no agency in the state of Texas, and I'll tell you why, wants to do anything with HOAs or POAs or CIDs, and there's about a dozen different acronyms that are out there. But the reason I believe that holds true is that we have 73 and no two of them are alike. Each one of them has a uniqueness that's almost impossible to put in any kind of pigeonhole or to characterize or to make in a list that you can uniformly apply whatever the rules or the laws are to them. So for you to have any kind of enforcement, to you have any kind of justice, for you to feel like that you have exhausted whatever remedies are available to you through the property code, through the government code, I'm going to talk about that in a minute, you have to go to the courtroom. There's no agency to complain to. If somebody complains to the real estate commission where your license is held, certainly how I always kind of candidly talked about it was that you're guilty until you prove yourself innocent. We really held a lot of folks' feet to the fire about things, and they had to prove their innocence beyond a shadow of a doubt. Administrative law judges, I don't know if you know this or not, at the real estate commission, you have your own courtroom. You have a thing called the State Office of Administrative Hearings, SOA, and for lack of a better term, they are ruthless. They will make your life miserable.
So, point of clarification, when you say you have 73, you're talking about your property management company that manages 73 HOAs, correct?
That's correct, yes. And we're growing leaps and bounds. We've taken on 6 in the last 2 weeks. I want to tell you why that's happening in a minute. I'm going to come back to that. But HOAs are prolific. 25 years ago when my mother died and I took over the company, I think there were about 8,300 HOAs, most of them in Harris County. Now there's over 100,000, and the number is doubling almost every 3 months. And don't let me get away too far. I'm going to tell you why that's a key point. Whoops, don't push that button. Oh, it's upside down. I couldn't find my remote, so I had to bring this one. I'm not very accustomed to it. HOAs do a lot of things. They are mandated to do a lot of things in several places. Most people think for whatever reason you go to the property code, chapter 202 to 211, and that defines an HOA. Well, that's not entirely true. HOAs fall under the Business and Commerce Code, that's chapter 86. They further fall under a subchapter called 22, where the nonprofits are, lots and lots and lots of rules. But basically, what they're required to do is take care of the commonly owned areas, the undivided interest that some owner may have in a park or in a. If you want copies of this, if anybody wants this, I gave that to Scott. He's got all these slides. You're certainly welcome to them. There's no secrets to this. If you want copies of the one that the CLE people use, I'll share that with you. But I think this is 46 slides. I think there's about 200 in that one, and it'll just, if you ever, I'm going to be silly now. If you ever read Hemingway, if you pick up a Hemingway book at bedtime, I dare say 2 pages is the most anybody can read before they'll fall asleep. And that's what this stuff does to you. It just puts you to sleep. It's just, boring is not even an appropriate description. So they're required, what they're supposed to do is take care of the common areas. They enforce things like you mowing your yard down where I live, and I dare say you're not guilty to it, a victim of it as well. The King Ranch people were looking for ways to feed their cattle. They brought a grass in from Africa called King Ranch Blue Stem. And it's very airborne, and if you see this time of year, the seeds will grow up 12 inches tall. It's very prolific. It's hard to get rid of, and we punish people for that endlessly, because if you get it and you become aggressive to get rid of it, it takes you about 7 years to rid your yard of it by constantly mowing it and treating it with different, if you're a holistic person, vinegar works. There's a lot of poisons out there that work as well. Noise, regulating parking. They do the architectural control committees or the architectural restrictions committees, where the buildings and the playgrounds, where you can put boats and RVs, where you can paint houses certain colors or not certain colors. They're more about prohibitions. Texas is a prohibition state. I don't know if you ever thought of it that way. We tell you what you can't do, opening the door to what you can do. That's the way the legislature is supposed to think anyway. Installations of swimming pools and extraneous improvements. Mailboxes, we have a neighborhood that mailboxes are very strict. You can't leave the lids open on them, and there's just all kinds of silliness. Fences, heights, materials, colors. But where they get this power is in an agreement, and I want to tell you where that really was further defined, but the agreement is the dedication, covenants, conditions, restrictions, otherwise known as CCRs. They get it from the bylaws, the organizational documents. They get it from what at 2011, the legislature took a page out of a 1977 law called the Texas Administrative Code, and now they have to record and define how they enforce, how they define, and how they apply the CCNRs. I'll get back to that in just a minute as well. 2011, the legislature said you no longer can foreclose for debts or for things that you were doing that were prohibited against. Now you have to go in front of a judge to foreclose on a HOA piece of property. Not hard to do. I've done it. I didn't enjoy it. I found no pleasure in doing that. But that shows you how vast the powers are, even if you've homesteaded. When that's usually the comment we get, well, you can't do that as homestead. Well, yes, I can. And if you read chapter 54 of the property code, the HOA has the same powers, thanks to New Jersey, a place in New Jersey. Thanks to them, we have the same powers as any first lien holder or any governmental agency. Most people don't see that coming. They think it's more like a club, more like it's a social thing, more like it's where you go to get a pass to go to the swimming pool. HOAs is where I can swap recipes, where I can get kids to babysit for me, or they're a pain in the rear about how I have to mow my yard or how I have to trim my hedges or whatever. Lots and lots of vast powers in HOAs.
Bill, is it still Harris County that has the highest rate of foreclosures for HOAs?
Absolutely. Fascinating point. I've done one in the 25, almost 26 years since my mother died. I'm a second generation, 1966. We're in the same location since then. I'm the new kid. I came in '77, but Harris County, to Scott's point, is these folks are just awful, and the Woodlands are even the worse than that. Is you don't do what they tell you to do, they'll line you up in front of the judge. The judge gives you 90 seconds to make your case. He's already made or she's already made his decision, and you're about to lose your house, and you've got 20 days to move out and find some bridge to live on. It's just really, really powerful. I think it was 2,800 in fiscal 2020. Fascinating place, and they've got all kinds of funny things down there. Y'all have fire ants up here. They have fire ant control areas. If you don't control your fire ants, they can fine you for that. Just goes on and on and on endlessly. We can sue you to collect fees. This is a very important point. Kind of hang your hat on that in a few minutes. I'm going to come back and tell you how crazy that can be, how absolutely ruthless Texas can be on that.
To build the foreclosure process, is it simply judicial foreclosure?
Simply, it has to be in front of a judge, yes.
Okay.
You know how under a deed of trust, you can just post it, substitute trustee, stand on the courthouse steps or wherever they designate that area, you can read a script and if you don't object, it's gone, goes to the highest bidder.
Right.
With these folks, they make us stand in front of the judge, plead the case.
So you have to actually file a lawsuit and go through the whole process?
Yes.
Okay.
And it's got a lot of opportunities. It's funny, you make a great point. It's funny to me how owners or members, or I like to call it, just simply won't rise to the occasion. They'll go, okay, I owe the money.
I got served.
I'll be packing up and leaving. But there's a lot of ways to fight these things. And that's where I think you come in, because if this is somebody you sold a house to and they failed to do something, they built a 4-story playhouse in the back or whatever it was that they're objecting to, cure the defect, get an attorney, put them on notice. You can't go to a JP, which is kind of the center of where all these things begin, but you can go to county court or district court and you get a stay. And you can cure the defect and chop the first 3 layers of the thing off. But you don't have to just cave in and walk away from it, take the whipping that comes with it.
Do most members never file anything?
I'm seldom, very seldom. We are in a lawsuit.
No, I'm just putting the mic up here.
Oh,
You're suffering, but keep going.
I'm sorry.
You're fine.
We're in a lawsuit over chickens. In the 5th year of chickens, we've won it 4 times at district court for 4 different reasons. They just come back and rehashing the same lawsuit. We've been to the 3rd Court of Appeals, which is like your 5th court is up here. The 3rd court sits in Austin. We've won that in an excoriating decision. If you want to read it, I'll send it to you. But it is vulgar. It is nasty. It is street language like you can't believe from a judge saying things like that. And we won that, and now they've appealed to the Supreme Court, and I was put on notice last night, oral arguments are in July. And so, I don't know. Why don't you just get rid of the chickens? And we fined them. I will show what the fine means in a minute, but I think we're up to about $200,000 in fines. They've spent over $200,000 in legal fees. My HOA has spent over $200,000 in legal fees. And I think to myself, why? And their argument, the underlying argument is they have a daughter that's 42 years old that they have discovered in the last 5 or 6 years when she's around, I don't know what that means, when she's around, she seems to be easier to talk to and to deal with. Well, how many times a year does she come and stay with you? And on average, 12 times a year, never for more than 24 hours. She's currently in France. And she looks at these stinking chickens on Zoom. And yet they won't get rid of them. In an HOA that very clearly prohibits chickens, poultry, or fowl. One of their lawsuits was over chicken. The word chickens does not define what you and I commonly go to churches and I don't know what y'all have up here, Popeyes or whoever sells fried chicken. It's not the same creature, according to them.
We got babies up here.
We need a gun.
So here's where everything changed. Everything, the whole world was turned upside down in this East Windsor, New Jersey lawsuit over community rights, over flags. It was all started about flags. And they argued the Greater Twin Rivers Homeowners Association versus the Better Twin Rivers versus the Twin Rivers Association, it's political signs, argued about political signs and how I was able to put them up and leave them up year round. And they went on and on and on and went all through the New Jersey, and they took it to the first court, which sits in DC, and they upheld the New Jersey decision. They overturned the New Jersey decision, and the Supreme Court, in what's called a no cert, which means we support and uphold the decision of the next lower court, they made a decision, but they went on further in the case to define that HOAs are like governments. They said an HOA is just like the city of Burleson, or just like Tarrant County, or just like the state of Texas. And they have the same rights, they have the same remedies, they have the same punishments, fines, all the things that go with that, as any city or any state or any entity that can tax. Another big word, big hurdle to get over. And so this changed literally everything we do and how we do it. To give you a little bit of an example, now I'm going to visit this again, in 2011, the Texas legislature said, wow, we haven't really defined this very well, so we're going to make HOAs subject to the Open Meetings, Open Records Act. Well, if you've been to a city council meeting, or you've been to a school board meeting, or if you've been to a nonprofit meeting, or you've been to the county commissioners, they all operate under the Open Meetings, Open Records Act, which means everything is transparent. You cannot conduct any business outside of the view of the public, whoever chooses to attend, other than 8 exemptions I'm going to share with you. But even then, you can't make a decision. You can't do a vote. You can't take action. You have to come back in front of the panel and share with them some of the salient facts, and then you have to vote in front of them so that they can decide, I'm not going to vote for Scott again because I don't like how he voted. And he's not going to be elected the next time. That's the only remedy available to those people. Same thing for HOAs. This is a major landmark lawsuit, changed everything in HOAs. This led to a lot of changes in 2011. We endured, if y'all know the names, Buddy West is Royce West, a senator from North Texas. Bert Solomon was a state rep. Worked for about 10 years. Every 2 years, they would come up with a monster omnibus bill that would cover 20, 30 items. I mean, it was crazy. And they all had it in one bill. Well, it finally dawned on them, that doesn't work. You're always goring somebody's ox somewhere in that bill. And I'm going to oppose it. My constituents are going to oppose it. I'm not going to support it. I'm going to knock that bill down. And it failed on 5 different occasions. Finally, in 2011, Bert Solomon's retired. And Royce West said, I give up. And 28 other senators and state reps came up with 68 different bills, of which 36 of them were signed into law by Bush. And that came to be known as the HOA Reform Act, the culmination. They actually named Chapter 209 after part of this. You'll see that in a minute. I'll put the name of that up there. And this started to use where we could use fines as motivation to not, remember Texas is a prohibition state, to not do things, giving HOAs requirements to disclose, procedures to enforce, procedures on elections. All these things that we had to do became very codified into Texas black letter laws. We had to adopt rules, we had to adopt record keepings, we had to adopt timelines, giving people hard, bright lines in the dirt of when you had to do things or then you couldn't enforce it. There's several examples of that. I won't get real granular with those kind of things. Some of the interesting things, though, this is where you really can come in. This is where you can show and shine to your people how important things are. For instance, in chapter 13.002, it says all these things have to be recorded and they serve as notice to everybody. We hear on a daily basis, nobody's ever told me. I didn't get notice. I haven't been given the papers. I don't know what you're talking about. You're making this up. Well, guess what? If it's recorded in the county of venue, it's applicable to that property, and that's all the notice we're required to do. Now, there's other things that we do, but that's really, fundamentally, that's what the judge is going to look at, is that's the notice of what we have to do. Second thing is if it's not recorded, you can't enforce it. So when somebody says to you, we've got this rule that says you have to paint your door pink every other year, show it to me in writing. Show it to me where it's recorded. Show me where the file marks are. Now, let me stop right there. That's where real estate agents are notorious. I can't tell you how many times I've seen this and heard this. Somebody's got to help these people. I'm going to go down and testify for them. I'm going to go down and file a lawsuit for them. I'm going to go down and hold these people accountable. Don't do it. Just don't do it. If you go to justice courts, they can represent themselves. They can bring you in as a witness, but you cannot be lead counsel on this. That's what attorneys do. If you go to county court, district court, or anything above that, certainly you have to have lawyers, all the formalities that go with those things. But this is where you can really, really shine when somebody starts to make this stuff up. You can only have 3 cars. You can only have people in the house 18 years or older. They can't do that if it's not written and recorded somewhere, and even then it has to be reasonable. So there's other things that we have to do in this management of associations, but part of it has to do with telling everybody how to find us. One of the hardest things people have in Texas is they are always looking for how to contact the HOA. They go out there and look and struggle and dig and whatever, and the title companies are the worst, is they will send us requests for paperwork, requests for production, and they don't have a clue who does that HOA. You've got to have one of these in the county of record for that HOA. It has to name the HOA, name the subdivision, has to provide the recording information, has to provide the recording for the declaration, has to give the name and mailing address of the HOA, has to name the person managing it, has to also give information that anything else the association says is appropriate. And we file these every year, and ours, well, I'm sorry, I got one slide ahead of myself. This shall be recorded in an amended document and always no later than 30 days after the date the association has change of any information about the HOA. So we have to update these things constantly. Ours looks like that. Our lawyer drew that up. That's just a blank one. It just shows you the name, and it's 2 pages long, and it goes on and on and on and on and on.
Did you say that's to be filed in the county?
In the county of venue for that HOA. It's not applicable if it's filed in Dallas County for Johnson County.
Not the state or anything like that?
Yeah, it just doesn't work.
So would that be something to where if you're trying to get a hold of an HOA and they're not getting back, or getting back to you, you can go to the county and look up for that document? Is that what you're saying?
I wouldn't go to the other county. I mean, they can't enforce it if it's not in the county.
To look it up, where we're gonna
The
find
title
it?
companies.
The title
I mean, I would suggest, my experience, let me say it that way. My experience is have a relationship with the title company. Find who to talk to in the plant to say, can you tell me who has the management certificate for the North Cliff Homeowners Association? And it takes them about 4 seconds. If you can't get them to cooperate, the alternative path for that is for you to go to sos.texas.gov. You're going to have to open up an account. You're going to have to tell them a little bit about yourself. You're going to have to give them a credit card, and they're going to charge you $1 for every search. And you can type in there North Cliff Homeowners Association. They're going to tell you two things that's important. And this applies to you for other reasons. At the Secretary of State, anytime any entity operates under any name other than my given name, or some, William and Bill, Lawrence and Larry, all those things don't count. But when I operate under the Good Old Boys Incorporated, then there's several other titles, several other hoops I have to jump through. But to go to the Secretary of State and to look them up again takes me about 15 seconds, costs me $1. I can look up and it will tell me who the agent of record is. And I can find that person under a number of different ways. They'll have their phone number, their mailing information. Do you have something, Scott?
Yeah, a question that came in online was how about ACC and generic authority they are given in the recorded CCRs? I think he's talking about the Architectural Control Committee.
Be happy to talk about it. The ACC is one of those unique things, often very germane to that homeowners association. These are folks that often are a panel this is my editorial statement, should never be part of your board of directors, because that eliminates the ability to appeal to the board of directors. They can't have a conflict, can't make a ruling and then rule on your own ruling. So the ACC should be a group separate and apart. They are defined by those recorded documents. They can broadly interpret things like typical and consistent. Those are real estate terms. They can broadly interpret things like offensive. If you paint something chartreuse or something that just doesn't go in the neighborhood, they could make you change those things. But most often they are defined by things like fence heights, fence materials, wood, new, not used. They are defined by buildings and building heights, building roof types. We have one of our HOAs that prohibits, I have to think what the word's called now. They prohibit a certain type of roof on sheds. I'll be darned. Anyway, gable roofs are the most common ones. I can't think. They have 4 sides instead of 2.
Yep.
No, they come up and they do an angle. And I've just gone blank, I'm sorry. But they are closely defined by what their authority is, by what's recorded in either the dedication and or the covenants, and sometimes lawyers will sprinkle these through the bylaws. The bylaws are typically the organizational documents to the HOA, but you can find some of those things that are scattered in there. But when you see things that your client, your buyer, your seller, whoever is saying this is typical and consistent, I don't think it's reasonable to have stone on the front of the building to match the stone on the front of my house. Then I think there are things there that you can certainly appeal back to a separate panel, the hearing panel that the board puts together. Often they'll put one member of the board members on there as a liaison, but again, this is an arm's length decision group. And then certainly if you lose at that level, you can take it before a magistrate, a justice, a JP, and let them make a ruling. But this is where the first thing I put up about dangerous to your health, this is where the Nazi approach to the onerous part of HOAs comes to play. We have a neighborhood full of, and please forgive me if anybody in the audience fits this bill, we have a group that is mostly junior league wives, and they absolutely abhor any child leaving their toys in the front yard. and they find that under the ACC as offensive, and they look to us to strangle their dog and shoot their children and fine them enormous sums of money. And so ACCs and boards can be a real power trip for somebody that's predisposed. They don't have anything better to do. They never had in a position of authority. When they die, they'll have flashing lights on their tombstone to promote their death. They're just odd people that they're all about themselves and never about the greater good. The greater good are words that simply don't resonate with them at all. I hope that covered kind of what ACC.
Now, what about like in terms of a pink door or something like that?
Well, again, if it's prohibited somewhere in the covenants, conditions, restrictions, and certainly there's a prohibition against it. The most common thing we see about that is a prohibition about religious symbols, and we see bird baths and yard ornaments that have angels or things that look like angels, and I've seen that go so far as to be gargoyles. People go nuts over those kind of things because they think it's satanic worship, or they come from the other side of that fence where they have a Confederate flag and a Confederate tattoo, and I don't know, you can imagine where I'm going with that. It gets out of hand pretty quick. So I think that it's very important, like we talked about earlier about foreclosures, don't cave in. If you think you're right, get an attorney, and not an attorney that does parking tickets and truancy, but somebody that's pretty good. You get what you pay for. We've got an attorney that does some work for us that charges $1,200 an hour. You can imagine he's pretty good. And when his name's on the bottom of anything, most everybody pretty much goes away and fades, and we no longer have an argument. A fellow named Butler, I don't know if y'all have seen that or not, he's a big HOA guy. I don't use him very often, can't afford him. You can see my point is you get what you pay for. I think the same thing with real estate agents. The discounters are driving me crazy right now. I know we're not supposed to talk about that, but the discounters are driving me nuts. Real estate certificates must be signed and dated containing the HOA information. This is found over in chapter 207. What makes this even more is it's applicable to the subdivision, but doesn't apply to condominiums. Condominiums have their own laws. I don't know if y'all do any condominiums up here. That's a real funny word called TUCA. It's the Texas Uniform Condominium Act. It's found over in chapter 82 and 83. I'm sorry, 81 and 82. There's a whole bunch of special laws for that, and you get that information again upon a request. But what makes this whole statement important, this chapter 202, is that we're entitled to levy fees. Those are taxes. We can operate whatever it costs to do these things. We have to have a budget every year. From that, we determine what the fees are. And unless it's prohibited in the covenants, conditions, restrictions, bylaws, we can adjust that accordingly. They do go down sometimes. Last night we had an HOA meeting that it very clearly will go down. Doesn't happen very often. These things, this is kind of an interesting statement. We have 10 days upon request to deliver these. I see people that never deliver them. Nonetheless, they have to. So you got 10 days upon written request, has to be a current copy of restrictions, has to be the bylaws, has to be all the things that govern the HOA. But then it has to have other things about first right of refusal, those things. But this is the second verse of this song. If they don't do that, they have a second appeal on 7 days. You give them 7 days to get that resale certificate to you. And if they don't do that, then watch the bottom fall. Whoops. The bottom falls out. Well, oh, this is where we can charge a fee to do this. But there's that 7th day. But look what they can do. They can get a judgment. They can, well, this says 100. They have 180. The certificate's good for 180 days. You can ask for updates. It has to be from the people that originally requested it, for the parties that originally requested. You can't. It's not a moving target kind of a situation. But if you don't comply with this, This is where the bottom falls out. This is where it gets pretty tough, is they can ask for a court order, they can get a judgment for $500, they can pre-empty any future charges equal to whatever the judgment is, so they can collect it from those, from any future sales. We have HOAs, a lot of these mom and pop HOAs, a lot of these that are ran out of cigar boxes, and somebody does it as an afterthought. They never produce resales, and the title companies just are forced to move forward. I'm very proud that we don't have any of these issues. Our deal is we give it to you the next business day, unless you're willing to pay an urgent up till 4 o'clock, we'll give it to you the same day for $50 extra. That's our rule. Here's the form. This is where you're requesting this, I'm sorry, this is the resale. This is old, this is back in 2014. This is back when Avis and I were still on the commission. You can see the number down 36-5. None of this has changed, but the thing that's the hardest to train agents, in my opinion, is this is negotiable. Who pays these things? You go down to paragraph E, there's a part down there that says who pays what, and it's worded very awkwardly. Lawyer talk says that the buyer will pay the first $100, the seller will pay the remaining fee. You just need to read it, negotiate it, use it to your benefit. That's that value thing I continue to talk about. How you get that information is this form. A lot of HOAs, a lot of the HOAs that are not run by anybody that's ever been in real estate charge incredible numbers for these things. $500 for public information. How many times have you been to closing and you see where somebody says, somebody sends your buyer a notice that says, we'll send you a certified copy of your deed for $10 or $25. What's the matter, public record? Why would you pay anybody? You get the point. So this is the document that's just been changed, and it was a wordsmithing change to be a little more clear on how it's applicable. I didn't really get deep into this. I guess I wasn't listening when Scott shared with me what he was looking for. But this, in my opinion, in our office, this is free. We'll give you all this stuff. We post most of it on our website. You can get it in the middle of the night. If you share us with this document, we'll give it to you. This is a buyer.
Aren't HOAs obligated to provide this in a easy to access form?
Okay, that's a great question. If they have a website, it must be on their website. A lot of them don't operate websites. Our HOAs historically don't operate their own websites, but we put it on our website. Each HOA has a place where you can retrieve documents. We don't think any of this is a big secret. Why people are charging these fees for these things, I can't tell you. I think it's a cash cow. I think it's people we just took over an HOA where the gentleman is a past felon. The HOA finally got wise and fired him and came over to us. We are finding where he's doing, anybody do any accounting, you'll have any accounting backgrounds, he's doing journal entries, he's doing wire transfers, and he's doing debit card purchases with no receipts. And so now they've referred it to, my dad was with the district attorney's office for many, many years. We referred it to them to investigate it. And I don't know if they're going to send him to prison. His lawyer's already been sanctioned over the Fair Debt Collection Act, the Obama Fair Debt Collection Act. So there's just a whole bunch of snakes over there where he works. I don't know. We get our authority from state law and from the HOA's declaration, or a combination of the two. A declaration, if you remember, that's New Jersey Supreme Court decision, Twin Rivers. It is literally a contract. The Supreme Court said this is an agreement. You buy property in there, you go to most closings, most mortgage companies will ask you to sign a planned unit development agreement. That's recognizing the contract, codifying it, if you will. But this is how it is. No matter what you want to call it, it is a contract. I didn't sign it. I didn't agree to it. Well, you did. You may not have known you did. You didn't have a good enough real estate agent. You didn't have a good enough mortgage company. But nonetheless, you agreed to it. Duties. The Texas Public information gives you access to all of our records. Sometimes it has to be from an officer, sometimes it has to be from an officer of the court, sometimes it can be you, but all this government information is available at all time to the public. There is some exceptions. The federal privacy laws, the state privacy laws control some of the stuff that we give, and we will only give it to a judge with a court order or a directive from the judge. But I think that makes sense to everybody, is you just don't want some of that private information or attorney privileged information to be readily available. Board of directors, that's a funny group of people. Often they like to get their hands dirty. Often they like to get right in the middle of everything. The truth is they are compelled by the Business and Commerce Code to do the directive. They make policies. Very often they want to get down and do the logistics. They want to go knock on doors. They want to kick somebody's behind. They want to tell them to move that car. They want to do all kinds of things. The truth is they really don't have the authority to do it unless they designate someone that's an agent of record person. That's where management companies come in. We do these things. We indemnify them. We hire people to do these things. We know where the bright lines are not to cross them. But the HOAs are defined by the Business and Commerce Code. They're a non-profit, in most cases, not all, in all that I know, they're a non-profit organization entity, which means they are not subject to, they're kind of like churches, cities, those kind of things. Not too hard to understand. When in 2011, they came subject to the Texas open meetings laws. Everything has to be done before anybody that wants to attend. If you want to go to a meeting, you can hear everything they make decisions on. All the rules are in this book. There's a class offered by the state of Texas that's free that you can go to. This lady is the division chief of that. She runs it. Takes about an hour and 3 minutes. You get a certificate. If you're just curious, don't want to go through all the testing parts of that, this is a training class, again, free, offered by the Ethics Commission. There are some exceptions to open meetings. I told you there were 11. Look at this. There's no CE, young man. Is this the office mascot?
Yes.
I like it. So personnel decisions from the HOA, you remember the members elect the directors. Those are things that are not open to open meetings. They don't have to discuss or put decisions in front of them. Pending or threatened litigation, negotiation contracts, enforcement actions. That's the most popular one. How bad we want it. This is a repeat offender. How much do we want to pound them? Confidential matters with the association's attorney. And then anything that invades the privacy of certain of individual owners, having to do sometimes with family disputes, having sometimes to do with partition. Y'all need to do, you need partition lawsuits. Y'all done any of that kind of crap? Those kind of things become very sensitive issues sometimes. So those would not be, no final decision can be reached in executive session. They have to come out and vote and do these things in front of everybody. As long as the governing body is in closed session, no decision or vote may be made on a matter being discussed in final action must be in open session. Those are all black letter law things. Here's where it starts to get pretty stinking heavy. This is over in Chapter 209. This is the Property Owners Protection Act. This is what came out of 2011. It says that they must put them on notice to cure a defect before something comes up, and there's a list of those things. Debts being further defined under the Obama Fair Debt Collection Act, and then there's a state version I'll show you in just a second. Here's the Obama Fair Debt Collection Act, and then the Texas Office of the Consumer Credit Commissioner. These folks only used to do pawn shops. They used to have 5 employees. Now they've grown enormously under the HOA Consumer Protection Act. I think they've got about 75 people over there now. But it's a debt collection thing. It has a lot of teeth in it, but it has a lot of protections and a lot of fairness in
What
it.
did they used to do with pawn shops and how did that come together?
It was a short-term loan,
Okay,
and so that's how they operated. Do you remember Paul Jordan?
yeah,
I got involved with Paul over, the other thing they did was when people financed, and this gets real organic real quick. Trailer houses and manufactured houses are not the same thing.
correct.
Trailer houses fall under the TDHCA people. Manufactured houses fall under the TDR people. I did a lawsuit as an expert witness for Paul on the foreclosure of a trailer house. And the Office of Consumer Protection sanctioned a guy because he didn't give proper notice and he foreclosed on the wrong trailer and threw away all this lady's historical stuff.
Yeah,
And he was a real estate agent, and the broker was taking the hit for it. And the agent, this is ugly, please forgive me before I tell you this. The agent was so embarrassed and so hurt by doing the wrong thing, the wrong trailer house, that his wife left him, his dog left him, his friends wouldn't talk to him. He went to the airport, stole a Cessna 172 airplane, went up to about 3,000 feet and parked it nose first in the parking lot of the real estate office. And that's how the case ended. And that happened while I was doing all the stuff I was doing that I was being hired to do.
Are HOAs subject to the FTCPA?
Yes.
So anytime they're trying to collect their dues, even though it's their debt, then
And that competitor that I've got that is in front of the Bell County District Attorney under investigation, his lawyer, Connie Heyer, you can look her up, she got hit by the Justice Department for violating the Fair Debt Collection Act. She became incredibly onerous on somebody, I don't know who it was or what it was even over, but they gave her a 6-month suspension from the bar out of it, which is kind of big money to a big-end
Yeah.
lawyer.
Wow.
So this all talks about what we can do, but the sentence that's the most important is down here in C, is if we go before a judge, and that can be in justice court, county court, that's what we just did, or district court, and we prove our point, we convince the judge, they can add up to $200 per day as additional motivation. And those add up very quickly. We're talking often about $1,000, turns into $11,000. Just huge. We just got a judgment of, when you don't show up, you get a default judgment. We just had a default judgment for $11,000 because somebody owed $2,000. These are the big teeth in here. This is the bad rap we all get from HOAs, where we're supposed to be out there measuring grass with a ruler. That we don't do that. I mean, it's obvious and apparent. We take photographs of everything we do. Everything we see, we have a photograph. Kind of silly.
That's your neighbor that might do that.
This is the hot button. This is the jelly of the week. This is what is haunting most of the conversations, most of the classes that I go to, most of the chatter you hear is over STRs, and everybody thinks, what's an STR? Well, what it's not is some kind of sexually transmitted disease. What it is a short-term rental. And so here are these HOAs that have been around for 1 year or 50 years, doesn't matter. And all of a sudden, there are people every weekend in the house next door with beer cans in the front yard and 23 cars parked on the grass and just noise all 24 hours a day. And so they're saying, we have to stop this. Somebody's got to stop this. This can't go on. So it's highly litigated. It's been going on now for about 10 years. And so these are some of the lawsuits. If you want copies of these lawsuits, I'll give them to you. Some of them are very long. Some of them are pretty quick to the point. This was Supreme Court of Texas. That was the 13th court down in Corpus Christi. These are all over short-term rentals. This one is another case in Corpus over a different HOA saying you just can't do it. You can't do that. You can't have the short-term rentals. Got to be 6 months. We want a copy of the lease. We want this. We want that. We want all kinds of stuff. This one is the one that's going on right now. This is just up the road from you in Grapevine. For about 10 years, the city of Grapevine collected from about 60 different properties occupancy tax. That's the same thing the motels and hotels pay. A tax for somebody to stay one night or 20 nights, doesn't matter. No leases, just an agreement the hotel and motel people use. They're found over in a different part of the business code. I think it's way up in the 1100s. And so this lawsuit's been going on, and the city was doing all these things, but all of a sudden a whole bunch of people came to the city and said, you got to stop this. This has gotten out of hand. This is crazy. The city needs to do something. I pay your salary. I want you to stop. You know how it goes. All kinds of noise. So the city stepped in September of 2019 and changed an ordinance that says no short-term rentals less than 6 months. Well, all these people that have been renting these properties, and let me stop there and tell you what that means to me, is we can rent a house, an average house, for about $1,500 a month. They can rent an average house with some dishes and pots and pans and bedding, whatever, for $1,500 a week. And so think to yourself, 60 or 70 of these owners, there's 11 in this lawsuit, are saying, whoa, you just got into my bank account. So they went out and got a pretty sharp law firm. They're very interesting how they've done this. And they sued them right back. And so the district court ruled in favor of the city. It was all I think it was all about politics. The homeowners went to the Fifth Court over in Dallas, and the Fifth Court did a thing that I don't see very often. It's a Latin phrase called en blanc. And what it means is 2 of the 3 upheld the lower court's decision. One person said, and you read it, you can't say that's an up or down vote. They said, I don't know. So the city said, whoa, well, hell, that's not a unanimous decision. We want everybody or nobody. And so they're still fighting it. These homeowners have now got some more people going in with them. Morrissey's her name, by the way, that's kind of heading all this up. I've never met her, haven't seen her, wouldn't recognize her. But apparently she knows what she doesn't know, so she goes and hires people that do know. And so they've got a class action lawsuit, and they're at the Supreme Court. So this is kind of undecided law. Each one of these cases is fact driven. Lots and lots and lots and lots and lots. The Grapevine case is in a 3-inch binder. All the documents I've got from it, I don't have a life. And so I print all this crap. I read all this crap. I look at it.
Well, it kind of pertains to your livelihood, so.
Yeah.
A little bit. So I try real hard to see what they're doing, and I've come up with a conclusion I'll share with you. And here's where that comes from. I'm sorry, one more case. This is the city of Austin. The city of Austin did the darndest thing. Very smart people. And what they did was got in front of this whole mess, saw it coming. Remember, they're a college town, 60,000 students. Well, more than that, all the colleges there, but TU, lots of students there. And so they got in front of it and they passed an ordinance. Not a prohibition, but an ordinance that said, here's the requirements. And so you can't have short-term rentals in the city of Austin based on this lawsuit and that ordinance they've done. But here's what we're seeing is if you don't have it from the very beginning, you can't, that the courts are telling us over and over again in their own words, fact driven, you can't just arbitrarily stop it midstream. But if you do it from the very beginning, this is a brand new HOA for us, he put in there not less than 6 months, you got to have a copy of the lease, all leases must be in writing, and we can enforce that. When you buy your house, The very first house, you knew from the beginning you couldn't do it, and the courts are upholding this. So it's a retroactive thing. Yes, sir.
Now, I've got a question for that, because there are people out there who go and lease properties, and then they'll Airbnb their leased property. That right there, how does that then apply to this? If you do have a 6-month lease and you have somebody who has that 6-month lease and is utilizing it as an Airbnb or whatever that company is during that time.
Perfect example. We've just been through this. Hire a realtor or somebody that has some experience. Don't get somebody that goes down to Staples and gets a lease off a tablet. Our lease says you can't sublease. Our lease says we can go in there anytime. We're going to try to contact you, but if we can't get a hold of you, just be up front, we're coming in. And so that subleasing, we just went through, okay, just evicted somebody that she, under the COVID, under the CDC, Supreme Court of Texas, what do they call those things? There's 36 of those. The Supreme Court went nuts when they said you can't collect rent from somebody that's that's protected under the CDC ruling. So the Supreme Court said, Texas said you can't evict somebody. CDC says you can't protect. That's called the CARES Act.
Yeah.
And so we had a girl that said, I can't pay. And we didn't have any, except under cause, we didn't have anything that we could evict her for. Get her out of the property and get our owner's money. And then we learned surreptitiously that she was subleasing the property. So for cause, a lease violation, we went after her because our lease is very clear that you can't sublease. And so she's not paying, I think, $1,650, $1,750, I forget the number.
No, it was $1,300 and she charged him $2,300 for the month, but couldn't pay rent.
But couldn't pay the rent. And so we're after her. She's a veteran with all these benefits, and we don't think this is her first time to fuzzy the lines up, so we're going after her VA benefits right now. And JAG is working with us. They haven't told us to go away. I don't know what's going to come from it, but to your point, those people all have their day in front of God.
Yeah.
So there's another question that came in online. If the community votes to change the CC&Rs, are the changes enforceable on owners that owned prior to the change?
Yes and no. That's a maybe. There are situations that are not heretofore recognized. Let me give you an example. Satellite dishes heretofore have been prohibited. Under George Walker Bush, the FCC said, wait a minute, we never thought of it this way. If you can't get communications any other way, you can have a satellite dish. And if you can only get it from the front yard up next to the street,
You gotta have it.
you got to let them have it.
Yeah.
So that retroactive thing is, in my explanation, fact-driven. But to their point, is it retroactive and carte blanche across the board? No.
Like if you buy a house, you bought the house and you had plans in 2 years to build a big shop in the back, which we allowed at the time because it was visually harmonious, blah, blah, blah.
Sure.
But then they update the restrictions to say no carports or no buildings in the backyard. But you already owned it and you bought it with that assumption under that. So could they build one or not?
I think they can, and I think their argument in front of the right lawyers, and I know who I would use, is that I'm going to use a word you may not be familiar with, under the procuring reason for them to buy the property, the producing reason. That was why they bought that. They can hang their hat. That's the reason I bought that house.
I would have bought it if I couldn't put a shop there.
There you had it. And I think their argument is going to get traction. Now, let me put an asterisk at the end of that sentence. This is my experience, nobody else's that I know of. The most feared 3 words in the English language is trial by jury. Nobody knows what a jury's going to do. I mean, it can just blow your mind how they can reason or not reason and get emotional over certain items. But that's a great question. And I think that, to Scott's point, it's going to be fact-driven how you can defend the reason that you bought that property. If it became in style to do metal roofs and there was a prohibition, I think you'd have a hard time overcoming that. At the same time, if solar roofs, which are very popular in some of our neighborhoods, under Obama's green energy thing that he kind of started, really got traction under him, I don't think you could stop it. And some of those solar roofs are almost impossible to distinguish.
Which is why they've also changed the 1 to 4 family contract now to reference leases on those things specifically.
And leases and chattels and fixtures and all that stuff, I'll tell you, that is a nightmare in litigation. And when I served, Avis and I both served, I don't know if y'all know who Avis is. When I served on broker lawyer at the Real Estate Commission, we wrestled with these questions, and the one that always stands out in my mind is in 1993, a lawyer from Dallas said, you know, in paragraph 2, we don't mention keys. So I guess you don't have to give them the keys. Well, that's kind of an assumption. How else do you get in the house? Break a window out? I don't know.
One other question. Would owners have cause if CC&R is changed to allow chickens when they weren't before?
Well,
And I think there's actually something going on with the Texas State Legislature right now that would actually prevent HOAs from being able to ban
poultry,
chickens.
yes. And what we're seeing, to their first question, is the CC&Rs being changed. I will tell you that in my 3 attempts, under the then used threshold, the new threshold, 67% of all the owners, not 67 of those that vote, not 67 of those that show up, not 67 of those that know how to write, but all means all, owners, vested owners, have to vote affirmatively to change a CC&R, and I've never been able to do it. I've tried 3 times and I've never overcome it. That was the reason I mentioned earlier is the Texas, in the 2011, the Texas legislature recognized the value of a guy from right here in Fort Worth, Oscar Mozzie, came up with a model called the Texas Administrative Code. It was brand new. Nobody had ever thought of those words before. And if you come to my office, I know Scott's been there, there's a great big laser picture, maybe 4 by 6, of the 5th floor in the rotunda of the Capitol building where I photographed with just my old Nikon camera, took it to pounds and they laser printed it, copies of the Texas, it wasn't called the Administrative Code back then, it was the Texas Records or something dating back into the 1880s. And so the Texas Administrative Code took the Texas Records, turned it into a daily catalog, but it also made room for the definition, application, and enforcement of laws that can be changed not by the legislature, but by the agency that holds the powers to do that. At the Real Estate Commission, we can't change legislature. We can't make you have more CE hours. We couldn't make you represent both parties. We couldn't make you represent only one party. The Administrative Code, however, gave us powers to define and enforce what heretofore we hadn't seen before. Teams, being the best example of that, are not defined or weren't defined until 2014 in the Texas Administrative Code or in the Occupations Code of who's responsible. And so that was one of the things I was put in charge of, was to define teams. And somebody, today's your day, you're accountable. Today we're going to take you out back and just whoop hell out of you because somebody else screwed up. And so that's kind of how that worked with the Administrative Code. Well, that's the same thing with these things, is you could hide those inside of that, how you're going to do it. It just has to be reasonable. One of the things they taught us at the AG's office was be reasonable. What would a reasonable person conclude? The administrative law judges think they're reasonable. I think sometimes they're nuts. Most often complaints we hear about late fees. People say, nobody told me I had to pay it on January the 30th. Well, the legislature did. What they did was they took off all of those previous agreements and they said everything's due on January the 1st, late on January the 31st. But what they did was give everybody payment agreements. If you apply for a payment agreement in writing, all late fees, all fines, all administrative costs, all postage, everything is waived, and you just pay it. I'll tell you about more of that in a minute. Number 2 is covenant violations. My neighbor's yard looks worse than mine. Okay, that's the defense that children use called 2 wrongs make a right. Very common. Pets. I want a monkey. It says no exotic animals. Well, Leroy's not very exotic. You should see the mess he leaves every night.
He was born here.
Yeah. Fireworks. Fireworks are defined in chapter 207 is until you can point out who's doing it and give us some kind of something to go from, it's a police matter, plain and simple. There's nothing I can do about it. Noise, very arbitrary. My wife can't stand a clock ticking. Me, I don't care, one way or the other. Wind chimes, same problem. Personal political expression, that's political signs, those are all protected under the First Amendment of the Constitution. The state of Texas has stepped in and said, yeah, but you got 20 days after the election, you had to remove them. Now, I'm still seeing Biden signs, I'm still seeing Obama signs up. I don't know what that's about. Well, I do know what that's about, but I'm not going to go there.
I don't know what the definition of days is.
Yeah. So anyway, these are all things that are things that we deal with almost on an hourly basis.
So I've got a question that came in that I think is a very important one, and I know you'll be able to answer it for us. So here's the question. So I live in a newer neighborhood, and our HOA is owned by the developer. There are 2 people in charge. They tell us we will not have any voted board or board members until the neighborhood is complete in 5 years. The neighborhood is already 3 years old. So talk to us about that.
Okay, that is statutory law. That's found over in chapter, I think, 202. And it says, until the developer sells 75% of the properties, he or she has absolute control. The reasoning, I went to that hearing, the reasoning is the developer has, not against their point, but to the other guy's point, is they sometimes have millions of dollars invested. And if they turn it over to the unwashed masses that don't understand any of this, we could go to all kinds of ugly, ugly levels. We've got a neighborhood that the developer just simply didn't care, and we've got corrugated metal fences. And I can't tell you how ugly. And he likes them best when he goes out there and sprays them with vinegar and they rust. And so you don't want to let the masses do it until you get to that 75%. Then they have to, the developer, the declarants, what we call it, has to elect one person or select one person to serve on the board. From that point forward, it's a backing out proposition until they sell all the properties. And there's a schedule that says we can add board members as we go. But for them to say for the first 5 years, I mean,
It could be longer.
It could be longer, it could be shorter,
Yeah.
but it's triggered by the threshold of 75%. Now, I think that's where the real estate agent comes in, is to create those private treaties between the developer and the buyer or the builder or whoever they represent, is to say, yeah, but we want this to happen at this point. We want some kind of input. We have a community that's very litigious, very unhappy about everything. They can't find happiness in front of them. And they have created an oversight committee. And they have gone after the board of directors so bad, last year they got to the point where they impeached, under chapter 22, they impeached every one of them. And so leadership is also a dangerous place to be sometimes. And if you don't represent the group, if you don't look for their best interest or perception of their best interest, could be they'll burn crosses in your front yard.
Yeah. Now, in HOA, they could choose to raise their fees at any point in time, and there's no max that they could change it, correct?
Well, in some there are.
Okay.
Some there's 10%. So we see numbers, but
Those
that,
are defined by the HOA themselves.
by the covenants of the bylaws.
Correct, yes.
But then, the offset to that argument is, okay, we can't raise assessment but by 10%, but we're gonna levy a special assessment to build a new pool or whatever. Now, that money can't be used on something else.
Has to be used for
It's
the-
earmarked for whatever you set it for. So there's all kinds of ways, and that's my argument. You and I were talking about this when nobody was here, is there's a House bill and a Senate bill. The House bill's been killed, 3867 has been killed, but Senate Bill's 1588 say they're trying to do what you're talking about, put lids on everything, what we can charge. Funny to me, they're saying the maximum we can charge is more. The only fee they can charge is more than we charge. I don't know why. There's HOAs out there extorting money, just stealing money, ridiculous sums of money. You want copies? Cost you $5 a page. The government code, chapter 70.3, limits it to 10 cents a page. But yet they'll charge you $10 a page to copy it, or $10 a document, or I don't know where they come up with these things. And so, by trying to put a lid or restriction on these things, Senate Bill 1588, I think it's what I said earlier to you was it's kind of a game of whack-a-mole. You stop them over here and they find 11 other ways to come after you. And the realtors, who I served as their 2010 chairman of the board, president, led them down crazy alleys. We fought some crazy fights. I don't know what they're thinking. And they're just not considering anything, and I think it's political hay they're trying to create, or the new guy that's the governmental affairs vice president, who's a nice guy from Corpus Christi, a CCIM guy. I think he's listening to other people and not listening to anybody that's telling him the unintended consequence. So I don't know where the realtors are going with this, but every day your mailbox is full of support 1588, don't do it. You're only hurting yourself. And if you read the arguments, which they're not telling you, CAI is publishing them, I'm publishing them, giving to all my members, 6,900 members. Just use some common sense. Just plain no sense. Any other questions? Last thing, what am I saying? Delinquent fees. Delinquent fees, assessments, or any other amount owed to the association without acquiring additional monetary penalties. This is that payment program I was telling you about. If you ask for a payment program, they cannot deny it. However, you cannot, I think that's this slide, you cannot fail to perform. If you say you're going to pay it on the 1st, you might could slide till the 2nd or the 3rd, but don't be paying it on the 15th or not forget to pay it, because they don't have to ever come back and honor it again for 2 years. And that has to do with fines or any monies owed. Monies. My wife's an English teacher. That was a word that she just cringes when I say that. Monies. Monies is stacks of money. Here's a stack of money, late fees. Here's a stack of money for fees. Here's a stack of money for applications. Those are monies. She doesn't understand that concept. Damn it. Her brother failed English several times. He can't say English teacher. He can only say damned old English teacher. When they apply your monies, this is the order they have to apply, and it goes to the assessment, goes to the attorneys and the association last. You can't prohibit solar panels, you can't prohibit satellite dishes, you can't prohibit rainwater, you can't prohibit religious symbols. There are some restrictions. Our religious symbols are 144 square inches. Rainwater harvesting, you can't have chrome barrels. Satellite dishes, reasonable, that's a federal law. Solar panels, anywhere you want them, just can't be bright and shiny. My favorite slide. And so it's just a real hard uphill battle. My point is, and I'll leave my card, and I'll leave my phone number. You're welcome to email me or text me. I'd rather you do it that way instead of calling me. I'll help you any way I can. I'll tell you who the good lawyers are. I can tell you who lawyers are that sitting in their pajamas in their den can solve your problems with little more than a phone call sometimes. I will tell you that bring money, the hardest part of that. This is a strange animal. This is not something that's, my education's in Western civilization. This is not something founded in society. This is not something that came from the great thinkers of Socrates or those folks. It didn't come out of the Queen's Court or the King's Court in England. It didn't come out of the Incas. It didn't come. This is something we invented. And it has to do with shedding responsibility. The proliferation, I will say this is an editorial, the proliferation of HOAs, I believe, and we experienced this, what day did we meet that Colleen guy? Thursday, Friday?
Friday.
One day last week. The proliferation of this is the cities are going broke. And the more they can shove over this enforcement on top of you, is the less they have to do, is the less they have to budget for. And so they want the developers to have HOAs or POAs or CIDs or any of a number of things, but they want them to do their own enforcement so they don't have to. And they can hold the HOA accountable. They had us looking at trash in a creek the other day. Well, I don't know how that's the HOA's problem. I think that was the builders that they licensed and charged to build homes in there. I think it's their trash, brand new neighborhood. But anyway, they're holding me accountable, or holding Tabitha accountable.
So there's one other question that came in. We bought with no HOA paperwork. In December, we got a letter from the developer requiring us to vote on a board of directors for an HOA that the developers were passing their authority to. No one here knew we were even in an HOA. Now we're not only in an HOA created by the developer, but that power has been transferred to a couple of neighbors. Is this legal?
Well, it's more fact-driven. There's things which your person didn't address, but if you remember in your Texas real estate promulgated contract, it says that the seller will cause the title company within 20 days. Let's see, the buyer will cause the seller to pay the title company within 20 days to produce all governing documents. So their beef, in my opinion, a good lawyer, is not with the HOA, but with the title company. And if the title company failed to produce it, or if the title company failed to contact, what's your name? If they fail to get her to send all the stuff that goes with it, then that's somebody's skin in the game and they can't enforce it. Now, I've got a $100 bill in my pocket, says in this situation, I'll bet you their documents are not recorded. That's what we see. That's the most common thing we see there, is they just go, oh, I forgot. And then you look at it, and none of their documents, or some of their documents, are actually recorded. Change of use, the dedication, the bylaws, the dedication, the covenants, the conditions, restrictions, any amendments. Something's not recorded, and then they can't enforce it. So a good lawyer stop all that.
Documents have to be recorded or renewed every how many years?
They don't have to be renewed,
Okay.
but they can be amended or changed, of course. But if they're not, that's in, do you remember the slide? I can go way back to it. Do you remember the slide that says in 202-006, to be enforced, they got to be recorded.
Got it. Maybe confusing that with deed restrictions. Deed restrictions do have to be renewed, correct?
Absolutely. Now, deed restrictions are a little different.
Yeah.
Deed restrictions are solely applicable to properties not subject to a planned unit development or a CID or any of that other stuff that the acronyms have become unmanageable pretty quick. But I'm here to help. I usually start out these kind of moments sharing with you that I am the most blessed individual you have ever met. I grew up in real estate. My dad was with the Texas Department of Public Safety. When I was 11 years old, I was exposed to a gunfight in a police car shooting at us. I decided that day I didn't want to be the police. My mother was a real estate broker, and here I am today. I've served at the Realtors as their president. I've served at the National Association. There's 13 vice presidents. For 4 years, I was Region 10 vice president. I've served at the Real Estate Commission. I've been to the Pacific Institute. I've been to the Army War College. Any of you in the military know where that is in Carlisle. I'm just blessed beyond any description. I'm the clown that wears a white suit, slips and falls into a mud puddle and comes up cleaner than I fell in. I'm just lucky, plain lucky. And my goal, my only goal in life is to make you better than me. Questions?
Anyone else have any questions?
I wanted to say something to that point, kind of the last person that just asked the question. I think
Yeah.
as real estate agents, it's helpful to be able to recognize if you are selling a home in an HOA, because I can't tell you how many people we get, buyers that are like, I had no idea that I was in an HOA, and then they're mad at you, they're mad at us, they're mad at the world, the title company, but then also in addition, that way you can make sure that the proper documentation, the resale is ordered, because we also get that where the title company forgets to order a resale, everything was so rushed or whatever the case is, and now the homeowners come to us and now they have this huge bill that they had no idea, and then now it's back on you guys or your broker or whoever, and it's just a big mess.
Just because there's no HOA fee monthly doesn't mean that the HOA just doesn't exist, because it's possible for them to not charge a monthly fee, but for you to still be in an HOA.
It's an annual, and almost all of them have some kind of fee structure.
Yeah.
But in the contract, starting in 1994, when we went from the 11-inch contract, the 14-inch contracts to the 11-inch contracts, we added a paragraph over in paragraph 7 that says it's subject to a mandatory membership in a property owner association, or not, yes or no. And if that box is blank, that's on the Real Estate Commission, and to me, that's an actionable complaint back to the enforcement, SES, to the Real Estate Commission, and they'll take you out back and first whip you, and then they'll put you in front of SOA, and you'll get to pay a big fine.
If there's, worst case scenario I can think of is that the listing agent didn't do their due diligence and
Oh, you're kidding.
and on the listing it doesn't say. Is there a best practice for a buyer's agent to, we have no idea there's an HOA. Is there a best practice to try to?
For $1, if they're willing to do that, for $1, I would go to sos.texas.gov, register. They're going to give you a number, they're going to give you a passcode, put a credit card in, you can do it all automatically, and research the name of that, what you think the name of that HOA is, and typically you can just put the name of we've got a few exceptions, the name of the subdivision. And it'll tell you if it's active or not active.
And if they have a website, they're required to put their CC&Rs up there?
Required to put all their governing documents up there, yes.
And if they don't have a website, the managing company that has the HOA, are they required to put it?
No.
No. And you choose
We
to
do it.
that? Yes.
Probably eliminates a lot of phone calls and whatnot.
Can you say that?
But that's it.
Can you say the website again?
SOS, Secretary of State, SOS.TEXAS, you have to spell it out, .gov.
Oh,
Everybody's kind of moved to that GOV thing. Used to be it was TX.USA or US, I forget. But we've kind of gone over to that.
One more question that came in. So let's say that an HOA, we're going back to chickens, okay? So let's say that an HOA does change to allow chickens, and when the neighbor next to them moved in, they moved in this neighborhood specifically because they don't allow it. Does the neighbor that doesn't want their next door neighbor to have chickens have cause to do anything?
Oh, to do anything opens the door to killing their real estate agent? Yes.
Within legal, within the parameters of the law.
One of the favorite things I say, I'm a firm believer, I am a big advocate of you going out and get your concealed weapon license. Even if you never carry a gun, it will teach you how to look both ways before you step off the curb. So my favorite thing to say is, when people say to me, are you armed? And I say, and there's the answer to your question is, you'll never know.
Yeah.
You want to find
And that guy that didn't tell them about the chickens, we're gonna miss him. I'm just a big believer that what makes you better, what makes all of us better, is the things we've talked about here today.
Yeah.
How many agents do you know recklessly and carelessly go through life? And they don't know, they don't ask, they don't know, they're afraid they'll be embarrassed. And you can ask Tabitha literally every day at my office, freely and willingly. I talk to brokers statewide, trying to help them the mistakes that I've seen people make. And I think we're all, if you remember the real estate pledge, underneath all is the land. That's what they forget. They get right to that point and they forget. But then you are duty bound to share the knowledge. That's in the second sentence below that. You share the knowledge. Help somebody keep from putting you in a jam.
Yeah.
It's not so much that you will lose. It's not so much that you fear of being embarrassed. It's what it's going to cost you to defend. And cost doesn't come in dollars always. My longest lawsuit took 17 years. I can't tell you how much time I wasted in that deal. Twice in Belton, once in Austin, once in Amarillo. We finally went to the Supreme Court, did oral arguments and won. But we lost everywhere until we got to Supreme Court. And it consumed my life for 17 years, nearly killed the gentleman I was working for. So whatever you can do to raise rising tide lifts all boats.
Yeah.
Help everybody. Share it. Yes, ma'am.
I have a question. So from Scott's online question, that the person moving to a community didn't know there was an HOA. Now it's new community. Now the developer is saying you have an HOA. What could I do as an agent where can I find this out? I know you said it's recorded, but if it's not, a lot of new communities are popping up, so nobody knows. What do I need to have on my power give them to say, you know what, in the future, if this comes up, here's something you can have if the title company doesn't do. I don't know.
For free, what we do, doesn't cost us anything, is all of our deed records, all of our county clerk records are online for free. Mm-hmm. And so we go out there and search every possible combination of names we can for that subdivision. And once we find it, then what I try to do, let me start over. What I learned early on in sales is how I resolved an unanswered question or how I resolved a potential question is to answer it before they ask it. So what I like to do is I'm showing him houses. He's really fascinated by the new 4-story houses in this neighborhood where they're all 3 feet apart. So we're going to go out and get as much information as possible. We're going to get the dedication. We're going to get the previous owner. We're going to get whatever we can from the landman. Do you know what a landman is? We're going to get whatever we can from the landmen because they'll freely give it to you. I mean, you buy them a bottle of whiskey, they'll do anything for you. I'm going to dig up the covenants. I'm going to dig up the dedication, the restrictions. I'm going to try to have all of that in advance so that all of a sudden he realizes that if he puts his boat there, they're going to shoot his dog or something. And often by you answering what I learned is by you answering those questions before they ever get a chance to ask them, they elevate your value to the limits. I never thought of that. I've got a lady right now that, I don't sell much real estate, but I got a lady right now that I can't make her understand. She's asked this question 25 times. It's, why are we doing all this? And my answer is always the same, because I don't want you to have the day after you own it to have any regrets. And so I've just wore her out with information and the history and who built it and all those things. And I think that's what value means to me, is how hard you want to work. My mother's best friend, they were both alive, would say things that just made me cringe. I can drag you all over town. I can show you every house in town, but that's the one you're going to buy. And I think to myself, I can't work with somebody like that. Why would anybody work with somebody like that? I want to know. People would buy homes from my mother out of self-defense because she was like a dog on a bone. She wouldn't let them go. Go away, we'll buy that house. No, go away. Me, I just want to drown you in information. And you can never say, you never told me that defense you heard a few minutes ago. But that's all contractually bound, and the Real Estate Commission is a consumer protection agency, and they will come down hard on agents that don't fill in all the boxes. There's a famous lawsuit went to SOA down in Corpus Christi where a broker was representing a church. The church, I don't know, it was a dwelling or I don't know what it was, something, piece of real estate, and he failed to mark several of the boxes. And so when it came back up, it was all assumed by the buyer, the buyer's agent, that that was part of the transaction, and it wasn't. It got real ugly, and the church had a memo where they told him that was part of the conditions of the purchase for them to either do or enforce or perform in some way, and the Real Estate Commission just pounded him right out of real estate. So here's my favorite, not my favorite, one of my favorite things to say, and I deal with a lot of fine people. I got some fine folks, so this is one of my very best examples right here, is I tell people all day long, I can delegate authority, I can delegate duties, I can delegate a lot of things, but I cannot delegate accountability. And so I think they rise to the level. And that's just the world according to God. That's kind of my way I look at real estate. Be accountable. Go out of your way to load them up. You know, we do binders for people when we sell them houses. And they got information there they have no idea. They'll have never any use for. But we'll track the deed back. I know how to abstract. I don't know how many agents you know how to abstract, but I can find it all the way back to the sovereignty of the soil if I have to. And I like that kind of stuff because it's like they look at it and they go, wow, I'm not going to bother him because it's right here in front of me. It's now my duty to look at it.
Yeah.
Am I overkilling?
Bill, I think you provided us with a ton of information today.
Well,
So grateful for the fact that you spent some time with us.
Always a pleasure. I'm very much committed to that. There is no secrets in real estate. What I did learn, what I said earlier and what I believe in is I'm very lucky. I'm very blessed. But what I found out was the harder I worked, the luckier I got.
Amen to that.
Thanks, everybody.